On Law Weekly today, we look at the legality of the ban on journalists by the General Military Court-Martial trying some Nigerian soldiers on allegations of mutiny.
To look at these conditions I've just given as provided by the Armed Forces Act and then object to it.
We also talk about the recent recommendations proposed by the House of Representatives on constitutional amendments.
For example, provisions that were passed here by the House, quite a number of them are not passed by the Senate. And therefore, you needed 2/3 of the Senate on those provisions.
And the alleged cash for arms deal controversy between Nigeria and South Africa. Our guest is the very celebrated legal practitioner, Mr. Femi Falana, SAN. As usual, he has very interesting views on these issues. That's the lineup for this episode of Law Weekly on Channels Television. I am Shola Shuyeli. Let's begin with a recap of the top legal stories that we tracked last week.
We begin with the report that the sentencing of South African Paralympian Oscar Pistorius has been fixed for Tuesday after the state prosecutor Gary Nell demanded that he be jailed for 10 years. Judge Thokozile Masipa last month cleared Pistorius of murder but convicted him of culpable homicide, the South African equivalent of manslaughter. Last week Friday, the prosecution and defense teams wrapped up their argument over what would be the suitable punishment for him, especially in the interest of retribution, rehabilitation and society. The prosecutor told the judge that the minimum term that society would be happy with would be 10 years imprisonment. He accused Pistorius of using his disability as an excuse and rejected concerns that the prison will not be able to cater to his disability needs. The prosecutor also criticized the offer of money by Pistorius to the Steenkamp family, adding that it was an attempt to influence, one which they had rejected. Defense counsel Barry Roach said Pistorius' actions were to some extent dominated by vulnerability and anxiety when it killed Steenkamp, especially as the court had found that he mistook the 29-year-old model for a dangerous intruder and that the shooting was a tragic accident. He argued that there was no conscious unlawfulness from Pistorius, even as he reminded the court of the athlete's fall from grace to grass in the last 18 months, an act for which he said the athlete had already been punished, lost sponsors, money, and was even too broke to pay legal expenses. The defense counsel urged the court to give serious regard to a community-based sentence. Pistorius cried in the dock during last Friday's proceedings and was hugged by family members and lawyers at the end. After 4 days of testimony from counsel on both sides, the judge adjourned till Tuesday, when she will pronounce sentence and bring the 7-month trial to an end. If Judge Thokozile Masipa imposes a prison sentence on Tuesday, the Olympic and Paralympic sprinter, who has been staying at his uncle's home since he killed his girlfriend, River Steenkamp, will be taken down to the holding cells, though he has the option of appeal and reapplying for bail. Back here in Nigeria, the coroner inquest into the September 12 synagogue church building collapse began last week Monday at the Lagos High Court premises in Ikeja. The incident left about 115 people dead and several others injured. Most of the victims were of South African nationality. Magistrate Oyetade Komolafe, who presided over the inaugural sitting of the inquest, assured the parties who turned up at the inquest that the court was only on a fact-finding mission and not out to prosecute anyone. The magistrate also asked members of the public with useful information that would assist the inquest to come forward and testify. He pleaded with the families of the South African victims to make available blood samples to the pathologist for easy identification of the victims, even as he urged the South African Embassy in Nigeria to send its representatives to the inquest. Last week Thursday, the coroner, representatives of the Lagos State Government, the police, journalists, lawyers to the synagogue church and other interested parties visited the scene of the incident. The coroner said the purpose of the visit was to get a physical view of where the collapse occurred in order to assist the inquest in reaching its findings. At the site, he directed the church to give the list of the people lodged at the collapsed building to the Lagos State forensic team led by the pathologist Professor John Obafunwa to assist the team in the identification of the victims, failing which they will be given a mass burial. Last week Friday, Justice Grace Onyabo of a Lagos High Court Ikeja dismissed a suit filed by the Muslim Student Association of Nigeria against the Lagos State government over the use of the Muslim headscarf, popularly known as hijab, by female Muslim students in the state. The Muslim Student Association had dragged the state government to court over the restriction of the use of the hijab on the ground that it violates their fundamental human right. The Muslim student also argued that banning female students from using hijab on or outside the premises of any educational institution in Lagos State is wrongful and unconstitutional. Justice Onyabo held that the restriction placed on the use of the hijab in primary and secondary public schools in the state is not discriminatory as claimed by the student. The court further noted that public schools were owned and funded by government, who therefore had the responsibility of issuing guidelines and dress codes for students. The counsel to the student, Chief Gani Adetola Kazim San, has however said that he will appeal the judgment. And after failing once again to secure its foreign witnesses in proof of the charges of fraud leveled against businessman Fred Ajudua, the Economic and Financial Crimes Commission EFCC has withdrawn the case. This forced Justice Kudirat Jose of the Lagos High Court Ikeja to discharge Mr. Ajudua. The SCC told the court last week Wednesday that its foreign witnesses are refusing to come to Nigeria because of the fear of contracting the Ebola virus. Ajudua and his co-defendant Charles Ore had been standing trial since 2003 for allegedly obtaining $1.69 million from two Dutch businessmen as sundry payment to various government officials who they claimed would help them to facilitate a contract worth $18 million on behalf of the complainant. Both men had however pleaded not guilty to the charges. Mr. Ajudua is however still facing another charge of allegedly defrauding former Chief of Army Staff General Shaya Bamaye of $8.4 million while they were both in custody at Kirikiri Prison in Lagos between November 2004 and June 2005. That charge is pending before Justice Oluwatoyin Ipaye, and Mr. Ajudua is currently at the Court of Appeal challenging the refusal of the judge to grant him bail on those charges. And we round off in Abuja, where the Nigerian Army has banned media coverage of the General Court-Martial of 59 soldiers accused of mutiny. The spokesman for the Army, Colonel Aliyu Yusuf, says the decision is in the interest of national security. He explained that witnesses in the trial are to give testimonies based on the ongoing operations in the northeastern part of the country, and in order to prevent a sabotage of the troops in the area, coverage of the proceedings will have to be suspended. Before the ban, however, a witness at the trial, Captain Idris Saleh, corroborated the testimony of the lead prosecution witness of how the soldiers refused to carry out the orders of their commander to fight the Boko Haram insurgents. The soldiers on trial had told him that they were not ready to die. The trial of the 59 soldiers for mutiny, insubordination, and refusal to fight the Boko Haram insurgents is coming 3 weeks after another 12 soldiers were convicted and sentenced to death for committing mutiny against another superior officer.